I wish you could swim like dolphins could swim. And then I'd say, so long and thanks for all the fish and welcome to the court gallery. Well, we're not all going to be heroes today, but we are here to enjoy some of the craziest court cases that have come out in the last 24 hours. Let me just tell you, every single day is another crazy day. What can I say? We're going to start things off with Judge Middleton. And Judge Middleton had a fairly interesting docket that was a mixed bag. But one thing was kind of ubiquitous through each hearing. They were all a little bit of a headache. We're gonna check a few of them out, right? Okay, we're gonna go from Judge Middleton over to Kansas with Judge Satterfield. She's sitting in with a couple that is a post-divorce discussion that, you know how these things go. And we're finishing the night off, ladies and gentlemen, if you don't already know, with the 401k Judge Simpson Donato craziness that happened today in the 14A. It's all interesting. It's all crazy. It's all frustrating, and it's a little bit embarrassing for those involved. And ladies and gentlemen, it all starts right now.
All right, the next matter is People versus Rhonda Ann Moser. File number is 2688FY. Ms. Moser is here with us by Zoom from the jail. Her lawyer, Mr. Tim George, is here with us. Ms. Moser, can you hear me?
Yes, I can.
All right. I saw this when you got arrested and was disappointed. You're charged with possession of methamphetamine as a drug double and operating while intoxicated as a third offense. Operating while intoxicated as a third offense is a felony punishable by up to 5 years in prison and 6 points and a fine of up to $5,000 and the suspension of your license. Your charge is a second habitual offender, which makes that punishable by up to 7.5 years in prison, and the drug double would make it up to 30 years in prison. So it's not good. I'm here with your lawyer, Mr. Tim George, and Chief Assistant Prosecuting Attorney Joshua Robert. Mr. George indicates you're going to waive the preliminary examination, have the matter bound over to circuit court, and excuse me, and but he wants to address your bond. Is that correct, Mr. George?
That's correct, Your Honor. We have, my client executed the written waiver yesterday at the jail. I provided that to the prosecutor. The offer in this case would contemplate a plea to the OWI charge and a reduction of the possession charge to a use and dismissal of the habitual offender notice. My client indicates that she's not currently on probation or parole. I think one of the big concerns that she has is she is currently doing online schooling through the University of Phoenix. If she remains in custody and is not able to get a hold of individuals at that school, I think she's concerned that she's going to lose the ability to continue on with that. The magistrate set the bond amount in $50,000 cash or surety. That's clearly an amount that my client is not able to meet. We would ask the court to consider whether a 10% provision would be appropriate in this case. I did talk to my client about the likelihood that if she were to be released on some type of bond, that she would have to comply with pretrial services. She indicates that she's amenable to that. That could include testing, tether, whatever the court would believe would be appropriate under the circumstances. So we would just ask the court for that consideration. And just so your Honor knows, she did provide me an updated address that's different than what's on the complaint. So I can provide that to the court as well. Thank you.
The address we had was Kalamazoo. Where are you staying, Miss Moser?
Oxbow Drive,
All right. With who?
Wendy, WP Bontrager. It's my daughter's husband's mother.
With your daughter's mother?
Husband's mother.
Oh. All right. This is charged as a third offense, drinking, driving charge. This is a rollover accident with a 0.196 blood alcohol level, also methamphetamine. And they had trouble getting you out of the car. You were not in good shape. Your license is also suspended. You also have $536 worth of unpaid fines and costs. Previous driving suspended from 21. I reminded you about it in November of 2025, disobeying a traffic control device and a speeding ticket. Mr. O'Bear, what's your position regarding the defendant's bond?
So I think this is a case where we do have to worry about the safety of the public. She has 3 prior OWI convictions, 2 in Michigan, 1 in Indiana.
So this is her 4th OUIL?
Yep. The one in Indiana was in 2021. That's the most recent. In that case, she was also charged with and convicted of methamphetamine. So it looks like she has 2 problems, methamphetamine and alcohol, in both of these cases. And despite the convictions in 2021 and whatever sentence was imposed, she's continued with both of those habits. So we worry about her getting out and the danger she posed to the community. So we would ask the court to leave bond where it's at.
Mr. Gibson, do you have input on this?
Is the bond, what is the current bond?
Well, this is
Mr. George's client.
Oh, okay, I'm sorry.
Yeah, you don't have it. You don't need to.
Is there another one that we need to do?
No, we're on to felonies.
Okay.
At one time, all of the OUIL thirds were just automatically set at $50,000. Can't really do that anymore. But this one, the magistrate felt it was an issue of public safety. She does have a bad driving record. It is her 4th drunk driving conviction. This was a rollover accident. She was suspended. She pled to a driving suspended in front of Judge Pattison on January 21st from November. Apparently just took care of that. I think she failed to appear. Let me look at that. She got a ticket on July 6th of 2024. She failed to appear in January. No, you can sit, Rhonda. You had that driving suspended from 2004. You'd failed to appear on several different occasions. You didn't deal with it until after you got arrested. So you had an open warrant for your arrest at the time you were arrested. Your license is suspended. It's a 4th drinking driving conviction with a rollover accident, a high blood alcohol level, and also a 2nd or subsequent possession of methamphetamine. You also have $536 worth of previous unpaid fines and costs. So the motion to reduce the bond is denied. You're not working, you're sleeping on your daughter's mother-in-law's couch, and you got some vague college tuition thing, but that doesn't outweigh the public safety issue. So the matter will be bound over to circuit court. If it's going to be worked out as a plea, perhaps sooner rather than later, you're going to get credit for all the time you're served, but I'm not going to reduce the bond. All right.
Thank you,
I'll do
Ryan.
an order.
Sir, I only have 56 credits to get my Bachelor of Psychology. So I've been going to college.
That's good.
It's not
Well, you
like I
didn't show
just,
up for court, you had open warrant for your arrest, and you're out rolling your car over with a .19 blood alcohol level. There's a consequence. Ms. Cowgill, you were either late or they didn't know you were here. I got a line up. What time did you get here?
Honestly, 8:48.
All right. Well, I called your number and it didn't go through, but I need to get the lawyers lined up again to deal with your case.
So we put our phones into a PS4 and I just let it charge because we watch music fall asleep. And I guess the TV turned off last night, and so did the charging to my phone. So when I got up this morning, my phone wasn't even on. So I missed my alarm and your call since I didn't get that call. I'm being charged by phone. I literally came straight here.
All right. Well, you're here now, so I just need to get, everyone was here when you were supposed to be here, and now we need to get them back.
The next waiver I have, Your Honor, is Dante Wright.
Good morning. Are you Dante Wright?
Yes, Your Honor.
Ms. Wright, I believe we met. You're here with your lawyer, Jordan Harden, charged with assault with a dangerous weapon and possession of firearm while under the influence. Hey, look at this. All right, for reasons I don't know, they didn't charge you with felony firearm, which is a blessing for you. Assaulting somebody with a gun as a felonious assault. If they charge felony firearm, it would attach a 2-year minimum sentence to it, but that wasn't charged. So you're waiving the matter to circuit court. It will be set for a status conference. I don't see that you owe us any money. Do you still live on, this is all messed up too, 8th Street?
Yes, Your Honor, I do.
And are you employed?
Yes, Your Honor, I have a job at Miners in Third Rivers.
All right. You do have a couple things. No, that's Daryl, right? Apparently you don't have any unpaid fines or costs. Mr. Wright, your bond is continued for your appearance in the circuit court for a status conference at a date to be set. Continue to comply with the terms of your bond and you're good to go.
Thank you.
Thank you.
And you got a freebie by not getting charged with felony firearm.
Make sure to check in from
What else do we know?
I will have to double check. Carrie Green, that matter, she was offered a misdemeanor today and talks with Mr. Robert, with her rejection of that offer. It sounds like their office may be pursuing that as a misdemeanor.
Is she here?
She was. I did not see her in the hallway. I'm gonna go check again. Maybe she was in the restroom. I told her to hang tight so we can make a
All right.
record.
David Sweet's been waiting patiently here.
Yes, he is a plea, Your Honor.
All right, let's talk to him.
Okay.
Mr. Sweet, come up and have a seat. Mr. Gibson, we were advised we were going to get waivers in both Guntle cases. Is that correct?
Yes, I need to go just over to the jail right now to talk to him.
I met with him this morning, Your Honor. I have him on the other file. In my discussions with him, he signed the waiver with me and he indicated he was willing to waive on Mr. Gibson's file as well.
All right, very good. All right, what else do you have, Paul?
I think as far as pre-exams, that was all. I just got the, there's a couple of preliminary exams today, but I think that was all I had.
Yeah, Judge P's got the prelim, so if he goes, and we're trying to
I
deal
think he had
with.
an arraignment still.
What?
Was there an arraignment he needed?
Mr. Guntle?
No, Mr. Gibson.
Oh, yes, I need Mr. Gibson for Miss, yeah, so stick around. Thank you, Jordan. Miss Cowgill showed up late and we'll do her arraignment here after we finish Mr. Sweet. All right, this is David Michael Sweet. Good morning, Mr. Sweet.
Morning.
Part of your legal education was to sit here and watch everything else that was going on this morning, so you were paying attention. You got charged with possession of methamphetamine, which is a felony, and we see lots of these. It's punishable by up to 10 years in prison and a fine of up to $15,000. It's a pretty onerous charge. Chief Assistant Prosecutor Joshua Robert is here. Mr. Robert, what's the plea offer here?
The offer is for the defendant to plead guilty to use of methamphetamine, dismiss the remainder, recommend time served, no probation. The defendant was just placed on a 24-month probation in circuit court on Friday for a possession of methamphetamine charge.
All right. All right, let's talk about this, Mr. Sweet. The complaint says that this happened in October in the city of Three Rivers, charged as a possession of methamphetamine with a drug double as a fourth habitual, which theoretically would make that punishable by up to life imprisonment. Prosecutors reduced on this to a misdemeanor charge of use of methamphetamine. That's punishable by up to a year in jail and a fine of up to $1,000. They're also recommending no jail and no probation. Is that your understanding?
Yes, sir.
Ms. Harden, is that your understanding as well?
Yes, Your Honor.
Other than this plea agreement, did anybody promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
You heard me go through the advice of rights a couple times this morning. Do you understand you have those same rights?
Yes, sir.
And you've executed a written one. You got stopped on your motorcycle at AutoZone. You had a small amount of methamphetamine in your possession.
Yes, sir.
Well, same thing. They sent it to the crime lab. You got arrested on 120, 119, and you bonded on 120.
I turned myself in.
Yes, I believe he turned himself in.
Okay.
Your Honor, so.
Who's your PO?
Jerry?
He just,
Are they looking at the probation center or anything, or?
Eric's band.
All right.
I had my orientation yesterday and dropped clean, and I got a call. Pivotal today?
Okay. Are you going to the probation center?
No.
You're just on probation?
Yep.
Well, there's no sense for two probations. And call it 2 days jail credit, 2 days. I'm gonna make the lowest possible fine, which is $125.
thank you, Your Honor.
That's due in 30 days. We'll make that due by March 6th. Yes. No, she's over here. Here's Moser and the other PEC. Plea. I can't make the fine any lower than $125, a $50 state minimum fee and a $75 crime victim right fee. Are you working someplace?
No, sir.
Well, the money that you're saving by not buying cocaine, you can use to, or methamphetamine, and you can use to pay this fine within 30 days. I waived the attorney fee and I waived any other fine,
Thank you.
but you're good to go.
Thank you, Your Honor. So, make sure that you haven't issued that.
We'll send a copy of the judgment to your PO.
Thank you.
Thank you, Your Honor.
All right, we lost Mr. George, but Ms. Cowgill is here, and so let's address her case. Would you come up to the podium, please? Are you Abigail Cowgill?
Yes.
You got charged with driving suspended, and I don't have Mr. George. He was here when you were supposed to be here, but he's not here right now. Maybe we can get him to help us. That was on January 6th. So let's take a look at your circumstance. You have an unpaid ticket for improper lane use from 2025. You owe $140. Well, let's take a look at this. I don't think I took it out of here. There it is. The ticket says that you were driving with a suspended license at South River Road and Lambert Road, not far from where you live, at about noon on January the 6th. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record, and it requires that your license be suspended. Let's take a look at your driving record. You're suspended because you didn't pay the ticket for improper lane use. You have an unpaid ticket in Kalamazoo for no proof of insurance. And this all happened while you're on probation. So you were restricted from 16th of January of 26. Starting January 16th, you get a restricted license. We're gonna need Mr. George. Maybe the city attorney will give you some consideration. Do you have money to pay your unpaid ticket that's here?
The 140?
Yes.
Yeah, I'm pretty sure I can.
All right. Why don't you have a seat and we'll see if we can get the city attorney. Do you know Bradley Cowgill?
Sounds really familiar. I think I do know him. I think he's like one of my cousins or something.
He's got an open warrant for his arrest. So if you
If I
see
ever
him,
get in touch, I'll let him know.
if you see him, tell him he needs to get in here. All right, you have a seat and we'll see if we can get the city attorney to take a look at this. Paul, maybe you can round Tim up or let him know we need his help on this case. All right, Jordan, let's go back to your cases.
Mr. Berkshire is reviewing the advice of rights for a misdemeanor plea right now in the hallway. We can make a record on Carrie Green. I think she left.
Carrie Green was an actress. She played the pretty girl in the movie Lucas, which is an 80s teen movie that I liked a lot. But I don't think that's this girl. All right, let's make an address or a description of this. Carrie Lynn Green, file 2690. What do we know about this?
Thank you, Your Honor. Ms. Green did call my office last night at 5 o'clock to get an appointment for today. Met with her this morning. As I briefly indicated, the prosecutor's position is that if she rejected the misdemeanor offer of larceny under 200 a day, their office would pursue this as a misdemeanor versus a felony, larceny 200 to 1,000. I let Ms. Green know that and advised her we would need to make a record. I'm of the understanding she did have some, either she had a ride with somebody or she had borrowed somebody's vehicle to get here today. So my assumption is she was confused and left before we could make the record, but she was here. I did have conversations with her, and I do have a phone number for her now. So at this point, I guess I will defer to the prosecution on how they wish to proceed.
Do you want me to just set up first of the month pretrial for March?
Yes, Your Honor.
All right. Jordan, are you here then?
I'm not, but I can be.
Well, I didn't know if you had some appointments or anything you had to be there. You don't have any March 6th pretrials yet?
No, I don't have a duty week again until like April, I think.
All right, well, I'll give you a bunch
Thanks.
at 8:30. And I don't like the part where they call their lawyer at 5 o'clock the night before their court hearing.
Yeah, her message had indicated she had just gotten a phone number or something of that nature, so,
They're given explicit instructions to call their lawyer, make an appointment to discuss their case with them. They're also cavalier about it. All right, and she's cavalier about this.
like I said, she was here, so I'm assuming there was just a misunderstanding about.
All
her
right,
having
well,
to
won't do a
place
bench
this on.
warrant.
Thank you.
Prosecutor, so it's misdemeanor set APT for 3/6/26.
Thank you.
And you saw Judge Stutzman's email and our responses. We're trying to stop appointing two different lawyers for the same defendants.
Yes.
And that's a MIDC thing. And it's very inefficient and it's stressful for you guys, so.
Right, and I didn't know if that was gonna be the position of the court for that Mr. Guntle case that was set today. Mr. Gibson has the earlier file.
I didn't make any action on it,
Okay.
but we're trying to.
I don't mind, I just wasn't sure.
All right, so Brayton Jennings, we're gonna leave on for prelim.
That's Mr. George's case.
Yes, that's what he said.
Oh, it's now Tim George.
Yes.
So that leaves Randy Berkshire Hathaway.
Yes, I will get him from the hallway. He was reviewing the advice.
All right. All right, that's who we're trying to find for you, Ms. Cowgill. He has cases in the circuit court and also next door. The jail. Good morning, sir. Are you Randy Eugene Berkshire?
Yes, sir.
You live on M86?
No, sir. I live 1327 River Street.
All right, down there on the apartments on the river?
No, sir. In a house on 3 Rivers,
Okay,
River Street.
all right. You've been charged with assault with Randall Wood with a baseball bat. That's charged as a weapon, felonious assault. It's punishable by up to 4 years in prison and a fine of up to $2,000. You're also charged in count 2 with domestic assault on Tamaria Pfeiffer, a resident or former resident of your household. That's a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. Chief Assistant Prosecuting Attorney Joshua Robert is here. Mr. Robert, what's the plea offer?
The offer is for the defendant to plead to 1 count of domestic violence. The felony would be dismissed.
Did you hear that, Mr.
Yes, sir.
Berkshire? Other than that, did anybody promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
Well, the felony is dismissed and you're charged with domestic violence, which is a misdemeanor. Have you ever been previously charged with domestic violence?
No, sir.
Then you could be eligible to have this matter deferred under the domestic violence deferral statute, which means I would put you on a probation. If you successfully completed the probation, the charge could be taken off your record. Mr. O'Bear, does the prosecution have any objection to deferral?
No.
All right, were you in 3 Rivers on that day, which was January 20th?
Yes, sir.
And who is Tamaria Pfeiffer to you?
My significant other's youngest daughter.
All right, did you and her get into some sort of disagreement?
Now, we was in the confines of our own personal bedroom and she come in ranting and raving. I asked her to leave. She wouldn't leave, so I just put my hand on her chest and tried to back her out and close my door. And that's it.
How's Mr. Wood play into this?
We were having an argument. And he threw something at me and I picked up the ball bat. I didn't wield at anybody, swing it at anybody, or even.
Well, that charge is getting dismissed.
Right.
She wanted to confront about mail to the house. Berkshire started to get verbally aggressive and push her out of his room. Well, that's consistent with what you said. She said she got grabbed in the neck. All right, I'm gonna set this for sentence. I need police report, photos. And victim input. In a domestic violence case, the court is supposed to set it at least 10 days out. So let's look at the calendar here, see when Miss Harden is available. So Miss Pfeiffer doesn't live in your house, correct?
No, sir.
So she's not there. You haven't had to move out. You're in your own house. Jordan, I don't know if I've got you set for anything.
I'm not, but my schedule, I know you like to sentence on Mondays, so, I can.
Let's look. Oops. How about March 9th at 10:30? Does that work for you?
That works, Your Honor.
That works for you?
Yes.
That's a Monday. Maybe the snow will be melted by then. For sentencing. All right, Mr. Berkshire, put this on your refrigerator. Stay in contact with your lawyer.
Mr. Berkshire is also one of the only ones who made an appointment, so.
All right, good
yes.
for you. That makes things easier and
Yes, it
more
does.
efficient. All right, thank you. Any luck finding Mr. George?
He's upstairs in the circuit court. He was doing a hearing up there. And, I told the deputies that.
All right, I don't think it's gonna work. She was considerably late, so
Thank you,
I'm,
Your Honor.
all right, thank you. Ms. Cowgill, I'm gonna reset you for a pretrial, have you come back rather than wait around. It could be an hour or more. So come up to the podium if you would.
I just have Mr. Rainey's sentencing.
You're supposed to get your license back January 26th. Did you get anything from the Secretary of State?
The only paper that I remember getting, and it's in my car because I keep it in there just in case I get pulled over. But it's a paper, basically what you said, stating that I was suspended from this time to this time, and then I'm on restrictions until this time to, I think, what is it, June or July?
All right, I want you to bring that with you.
Okay.
I'm gonna reset this.
And I did get insurance on the car. That's all paid for. That's all good.
You also have an unpaid fine
Which one, where's that from?
from here. It's $140. I'll send you out to see the clerks.
Okay.
Here's Mr. George. Jordan, are you done?
Mr. Rainey's sentencing.
Oh. He's in jail. Did they bring him up? We still have Mr. Moore's guy. How old's your baby?
She'll be 3 months, February
Well,
17th.
she's been quite cooperative. You've been here for a long time.
Yeah,
That's one of the reasons why I wanted to try to take care of this
Yeah,
today.
you're good. You're good.
Easier, you got it.
All right. Do you have any source of income?
Me? Yeah,
Yes.
yeah, obviously. Yes, I work at O'Reilly's in Portage on West Edge.
Are you off on maternity leave?
No, I didn't take my full maternity leave because I wanted to go back to work and I needed monies. So, I don't remember.
All right, well,
the
here's
date.
the ticket that you owe. All right, I'm gonna go ahead and adjourn this. I don't know what Mr. G just came in and did a flyby. If you pay off the existing ticket, they may reduce this to allowing another to violate the motor vehicle code.
So sorry if I'm maybe it was, so the things that did suspend my license were the unpaid tickets.
And an unpaid ticket in Kalamazoo, but then they gave you a restricted license in January. You got this ticket on January 6th. You didn't get your restricted driver's license until January 16th.
Oh, okay, the one that says verify restrictions on record. That's why I got a new one. Okay.
All right, so if you get a driving suspended from January 6th, it's gonna undo your restricted driver's license. And you're gonna get suspended. That's why I was hopeful that Mr. George might be able to reduce this charge.
Does the Kalamazoo one tell you what it was for or no?
It says, fail to stop within a short clear distance. It looks like you paid that one.
Oh, yeah, I remember that one.
Improper lane use here in Centerville, which I just gave you. Here's Mr. George. I know you bet. She was late for one thing. You were here when she was supposed to be here. This is Miss Cowgill. She got a driving suspended ticket in Three Rivers on January the 6th. She was suspended because she got some violations during her probationary period. She also has an unpaid ticket. She got this ticket on January the 6th. She got her license back as restricted on January 16th. To and from work, employment, course of employment, medical reasons. So as of right now, she has a restricted license effective January 16th. If she gets a driving suspended on this charge, it will undo that. She has an unpaid ticket of $140 for improper lane use that she's willing to pay. I didn't know if this is the type of case you'd reduce to a 257, 326.
Yes, sir.
Because you were late, it caused Mr. George and Mr. Gibson to be here for 2 hours waiting to handle your case. And I thank both of them. What I should have done is just had you come back, but you got a very small baby. And Mr. George has offered to dismiss the driving suspended charge, which would cause your license to get resuspended. He's willing to amend it to a charge of allowing another to violate the motor vehicle code. That carries no points, doesn't get abstracted to your license, won't affect your ability to keep your license. You understand? Are you willing to plead to that misdemeanor charge?
Yeah.
All right, I'm going to give you a fine and I'm going to give you some time to pay it. Now, the officer eventually gave you an advice of rights. Do you have that with you?
Yeah. 1 second. Sorry.
All right, other than this plea offer of this charge that won't go on your driving record, did anybody promise you anything to get you to plead to this
No.
or threaten you?
No. What's the date? Third, second, third. Put the address of the
Name, address.
Good morning, Paul.
Restitution hearing at 10 o'clock. Since he has a case document with you.
Well, he's been here for 2 hours. I don't know what he's been doing.
He's just gonna wait.
Yeah, he can just file a written waiver. Sometimes there's an issue of whether there's a violation, but there is none, so he can just file a written waiver.
So he said 15 minutes if he went down here first, but
Well, this would take 1 minute, but I don't know where he's been.
he's been in the building. So
I know, I saw him, but he must have been talking to his client for 2 hours.
okay.
He can just submit a written waiver. Okay. All right. Ms. Cowgill, were you driving a car on January 6th at about noon in Three Rivers?
Yes.
Where were you going?
So he worked, so he has to be at work at 10 and he works at Casey Auto Land in Kalamazoo. So I dropped him off and then I think I had to take, I don't remember.
Who's he? Your child's father?
Sorry, yes,
Okay.
right there. My bad. I went to go drop him off at work and then I don't know if
You work in Kalamazoo and he works in Kalamazoo.
we used to live in Portage.
Okay.
Yeah, and our lease ended and we had to move in with my parents and all that fun stuff.
All right,
But,
all right, so you're living with your folks right now?
mhm.
All right, you got your license back, restricted. You can drive to and from work and other limited purposes. But this ticket on January 6th was before they gave you your restricted license on January 16th. Is that correct?
Yes.
All right. I'm gonna fine you $75 crime victims' rights fee, and a $50 state minimum fee. I'm gonna fine you $200. I'm gonna give you till the end of March, because I want you to pay the other ticket first. This won't go on your driving record, and it won't affect your ability to keep or maintain your license. So you can pay it by credit card, green cash, certified check, or money order.
Okay.
I want you to pay it by the end of March. If you need more time, come see me.
And that's the $200?
Yes,
Okay, I
you owe
can do that.
140 on the other ticket.
I can 100% do that. I got you.
All right, you're good to go. Thank you, Mr. Gibson.
Thank you,
Thank you.
and thank you for the people that had to stay over. I'm really sorry.
All right.
I'm not happy again, ever.
All right, Paul. Let's bring Mr. Rainey in. The only prelim we have left, or pre-exam, is Braxton Camp. It's another case where they didn't charge felony firearm. They must know something I don't. And I'm told he's gonna waive, told by Judge Stutzman, who needs Mr. Moore for a hearing in circuit court.
Yeah, I know Mr. Moore came in with Mr. Robert half hour ago.
They've been working on it, I think.
Yep.
Morning, Mr. Rainey.
Good morning.
This is file number 25838 SM, People versus Eric Richard Rainey. Charges malicious destruction of property less than $200. Mr. Rainey pled to that charge and then he failed to appear for sentencing. A warrant issued for his arrest. He pled no contest on October 30th. He didn't show up for sentencing and a warrant issued for his arrest. He got picked up on the warrant and I set it for the next date. His lawyer, Jordan Harden, was scheduled to be here, which is this morning. So you've been in jail 8 days from that, and you had some jail credit earlier. Which I think is 2 days. So I think you have 10 days of credit. The allegation is that you got mad at some girl because she wouldn't let you live with her or move in with her, and you punched her hole in her television set and stomped out. That's what you pled no contest to. Ms. Harden, anything else you'd like me to know?
Thank you, Your Honor. The complainant in this case is my client's mother. He did enter no contest plea to resolve this matter. As the court has indicated, he does have some credit for some time served. I would let the court know that I represent Mr. Rainey in his pending felony cases in the circuit court. We did have that arraignment last week following this arraignment, and Judge Stutzman did cancel his bond in those cases. So in light of that, I'd ask the court to impose time served. I don't think Mr. Rainey's in a probation or in a situation where he could be successful on probation, just because we do not know the outcome of those other cases, and he's sitting on a canceled bond. So I'd ask the court to impose the time he's already served with minimal fines and costs. Thank you.
Mr. Rainey, anything else you want to tell me?
Not sure. Sure.
Yeah, you were like a cork in the ocean floating around.
It's hard for me to get around because I don't have a license and I don't have a car. And I don't have a working phone, so I can't, it's hard to stay in contact with, my court dates and getting transportation here.
All right, well, you're here now and your bond's canceled, so no matter what I do, you're not gonna get out,
Right.
so I'm just going 10 days jail credit, 10 days. 0 days to serve the minimum allowable fine of $125 or 2 additional days. I'll reserve on restitution. All right, Mr. Rainey, you're good to go.
Thank you.
Jordan, would you ask Sergeant Rice to come in?
Keep wanting to respond when you say that. I'm like, yes.
Oh, Jordan, I told you there's a Peter Wolf song called Hey Jordan. He said it's a boy's name on a girl.
I had a neglect case where the mom was named Jordan and the DHS worker was named Jordan and I was on it, so like.
Josh, Judge Stutzman came down and said he needs David Moore. And David Moore told him that Braxton Camp is gonna waive.
Yeah, I gave him a paper waiver.
That's another one where they didn't charge him with felony firearm. Oh, they did charge it. There's a felony firearm count in there. Very good. Yes,
Rice is back at the sheriff's office.
all right.
Thank you, Your Honor.
Thanks. We got anything else we need to address?
No, Paul's on the way to the jail and then just that camp case, so
All right,
hopefully
I
those
think
both
that's
waivers
everything
come.
we had to do by 10:30. All right, thanks for your help, Josh. These always go smoothly because you're on top of it, so I appreciate it.
Thank you.
Mr. Robert does a good job on his cases, which I appreciate.
All right, can you hear me all right?
I can, yes, Your Honor.
Okay,
My
we
vid-
can't see you.
I know it's something to do with my settings.
Okay,
I apologize.
all right. We are going to go on the record in the matter of the marriage of Timothy Glenn Weber versus Carla Marie Weber. The plaintiff appears with counsel by Zoom, Ms. Jessica Sir. The respondent continues to appear self-represented. This was a contested divorce with no children, and the court held a trial and made specific rulings. It did involve a rather sizable equalization payment to the respondent. And Ms. Sir, my understanding is that when you tried to deliver that or have something coordinated for Carla Weber to receive the check and sign a satisfaction of judgment, that she refused to, or you were unable to accomplish that. And so you attempted to deposit it with the clerk of the district court and were unsuccessful there. And somebody asked if I wanted to keep it, and I don't have a safe in my office. No, I don't want to keep a check like that. I apologize that you weren't able to deposit the check. I really need to check with Topeka since everything runs through Topeka now. And our clerk of 40 years left, everything's changed a little bit. And I'm not sure that on every divorce case, if there's an ordered equalization payment, that there's a ledger open for that.
Sure.
I do have attorneys I went back and looked that have filed satisfaction of judgments in domestic divorce cases So it would make sense, and I just haven't been able to catch the chief judge and kind of figure out what the situation is, or if there's any kind of solution. So that's why we had to schedule this for hearing. I obviously I'm waiving, I'm holding in abeyance any kind of interest on this money, because of the current circumstances. Now, Ms. Sir, you filed your motion. I was going to grant it if it hadn't been responded to within the period set out by the Supreme Court. But Ms. Weber did file an objection, is how I would take it, by way of email. And I assume you got a copy of her email dated Thursday, January 29th at 9:50 a.m.
Yes, I mean, she sent several emails to the court that I was copied on.
Okay. Yeah, it looks like there's more here. But what I'm focusing on right now is the equalization payment pursuant to the journal entry and getting that taken care of at this point.
Do you want me to give you my client's position on that?
Yes.
Okay. In the journal entry to create a divorce, you granted an equalization payment or a property settlement payment, however you want to call it. And then in the journal entry on page 10, you made specific orders with regards to my client moving items into a storage unit and what he could charge for the labor, and indicated that that would come off of the equalization payment. You ordered us to get that done by December 2nd, I believe was our deadline, and we were to file a receipt with the court, or an accounting, I guess, with the court, which we did on that day. December 2nd, 2025, we filed an itemization of moving expenses. What I think is happening is that Ms. Weber doesn't like your order and doesn't think that the moving expenses should be deducted off the equalization payment. But she's beyond the time to file a motion to reconsider. She didn't object when we sent her the accounting that we filed on December 2nd, but now is
Hold on just a minute. I'm sorry. Hello? 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 I'm sorry. My private line never rings, and it was ringing, so I thought maybe it was something urgent. I apologize. Go ahead.
So at this point in time, she hung up on my assistant when my assistant called to tell her that we had the check. I think now she's saying that was an error. She didn't mean to, but she didn't call back or clarify or make any efforts to come pick up the check. So we then had my client, it was a certified check. We had him take it back to the bank to make the certified check out to the clerk. And I've never had an opposing party refuse to pick up a judgment and sign a satisfaction. So I talked to some people and was told that you could pay into the court and that it was done pretty regularly in civil cases. I'm not sure it's done obviously that often in family law cases. So all we were trying to do was get the money to either her or to the court, so then we could file something with the court and have the court find that he satisfied his obligation. You know, I think it's the only thing that we're truly here today on is my motion to ask the court to either, my motion asks that we can pay into the court and then file a satisfaction of judgment that the court approves, or I guess my client can go back to the bank for a third time and change the certified check back to her name, and she can come and pick it up and sign a satisfaction. But with my client being awarded the residence, I don't want it to be a situation a couple of years from now or whenever, if he ever tries to sell the house, that there's not a satisfaction, and then there's a concern that he doesn't have clear title to the house, or that there should be a judicial lien. So having the satisfaction is really important. I don't think that it is proper for her to seek relief from the court order today, because her time to ask for that, I believe, has expired. If she had an objection to the itemization that we filed, then she should have objected back in December and not waited till we tried to make the payment to make an issue of it. I will tell the court that on that itemization, we outlined in pretty good detail and had a bunch of attachments to show the amount of time and effort and the expense that my client incurred to move the items. One issue of contention is that my client rented the only size of storage unit that they had at this point, storage in El Dorado, and filled it. It was full of probably a few inches from the ceiling. And so we did rent a second unit then to be able to comply with the court's order of getting it all into storage. So I think one of the objections is the fact that there's 2 storage units he rented, but the first one got full, the second one was almost full. And so that's what he had to do in order to comply with the court order. And then we really outlined in there all of the hours spent trying to comply with the court order and to get everything moved. So I don't believe that anything that the court can or should do anything other than say, my client complied with the court order, he filed the receipt, he then cut a check for the amount that the receipt showed he should pay. And at this point in time, I'm fine to send it into the court. Again, I guess I can have him go back to the bank for a third time and switch it back to Carla's name, but I do want to know that she's obligated to sign a satisfaction. It's not fair to my client to continue to incur attorney fees in trying to get this case resolved and wrapped up when he's complying with the court order and we're getting opposition in a way that's not proper, proper to bring a concern to the court. So that is my position, and I can answer any questions that the court has.
Well, the only thing I'm actually interested in, Ms. Sir, and I'll hear from Ms. Weber, but Ms. Weber, I have to take note that the journal entry was filed. Your choice then is to file an appeal. The itemization of moving expenses and the move was complied with. And in this court's view, this was due to the exorbitant amount of personal property from inheritance of family members that was in that house that was frankly taking forever to get moved out, and you wanted it all. So this was the court's solution to trying to preserve the majority of your property that you couldn't seem to move, and allow him to free up the house he was awarded to clean it up and do as he wanted to. But and then there was never a motion for reconsideration or any objection to the filing on December the 2nd of the itemization. And these all needed to be filed anytime you file objections. As we've told you before, when you file formal pleadings in response to pleadings, they need to be filed in the court file, and it's not up to us to do that. But the only thing that I will say, Ms. Sir, that I am interested in inquiring about is that somewhere in here, she mentioned that she believed that it was possible that Kevin Unrein was doing a favor, and that your client didn't actually pay. So point me to evidence you have that he paid out of his account or his monies or in some way the money that was charged with regard to Mr. Unrein.
Let me put you on mute real fast and talk to him.
Okay.
Judge, it's my understanding that this Mr. Unrein is the person that owns the storage unit. And he's not lending my client the storage unit at no charge. My client couldn't sign a 6-month lease, so he's paying month by month, but he is It's not that he got these 2 storage units at no cost as a favor. He is paying for them. So
And does he have receipts, canceled checks?
I don't have them. I don't know that I have them with me. Yeah, I mean, I didn't know we were gonna have to actually prove that he was paying for the storage unit. So, I mean.
Copies of that first running of it.
Yeah, we included the lease and the paperwork in the itemization. Exhibit A that shows what he's paying, and what the late fees are. I can get proof of that, but I mean, I feel like the leases should be sufficient to show that he's not. I mean, there's 2 rental agreements, Exhibit A and Exhibit C.
Right. Well, I would like you to file receipts for what he's paid so far to show that he's actually making payments, because I don't want to leave anything in the wind with accusations such as that. And the only other thing is, I assume if there was mouse poop anywhere, it's possible that it accumulated while a lot of this stuff sat in the house or sat in trash bags, and that there was any intentional damaging of any property, or I don't know what you do, put a mouse in a bag or what, but.
No, my client, I did ask him that specifically. He did say that there are and historically have been mice downstairs in the house. And obviously, if you've got piles of stuff in your basement, as there was in the pictures we had at trial, I'm not surprised that there was mice in some of that stuff, or that might have happened. But it was nothing that my client did intentionally whatsoever.
Okay. Well, I mean, when she lived there were lots of cats, so we probably didn't have as much of a problem. But the long and short of it, Ms. Weber, is I know that you aren't happy with the court's order. I know that you don't appear to be happy with how stuff was unloaded, or what was put in the front and what was put in the back and what was stacked, and the condition of some things. But the court finds that he is in compliance with the court's order. And yes, I thought this is something that could be done for around $2,000. I didn't know it was going to be $4,000 or $4,140. But I saw the pictures. There was just a lot of stuff in that house, and so I wouldn't know firsthand until you delve in there what all you'd be dealing with. And I believe proper documentation has been provided. I am going to ask for additional receipts, either cash receipt or canceled check or something to show, or a debit receipt or something to show that payments were actually made. But Mr. Weber, as a long-term law enforcement officer, has a lot to lose by lying to the court or trying to dupe you. And I find it hard to believe that he would put his reputation or his life work at risk by filing false documents. I just and I'm not going to go there. So what I need to know from you is, how do you want this check? I will have to have them file an order signed by me to pay it into the court, and then I assume they're going to take it, and then the court will hold it for you to come get. And there won't be any interest assessed until you pick it up. It won't begin to accumulate statutory interest. Or he can get another check, and I can give you a certain amount of time to get up to their office and get the check and file a satisfaction of judgment.
Your Honor.
Yes.
If I could address the original order back in December, when you had allowed $2,000 for moving expenses, be taken out of, well, you awarded me $2,000 of Walmart stock, and that would go for moving expenses. So in December, when I was sent the itemization, the moving expenses weren't part of that I recall. And when I was sent the bill, if you will, from the point storage, and when I realized it was over $4,100, I couldn't believe it, because everything that was there that I had given way back to Two Men in a Truck, when I tried to get them to move everything, I had listed everything to Two Men in a Truck, and they told me it would be anywhere from $1,200 to $1,500, and that was to move it from the house on Sunset to a storage facility here in Bel Air. So I found it hard to believe that when a professional moving company, their top dollar was $1,500, then when I got the bill and receipt for 2 storage units, which in your order you said 1 storage unit, and then for 6 months for 2 storage units, and the first one's not even full. I had sent those pictures to Ms. Scher and Ms. Beckman as far as showing what was in front, which is the only picture Ms. Scher had sent, and what was behind that. There's a whole bunch of open space that things could have been stacked, and it's not even up to 2 inches to the top of the roof. And Tim also knows that I have low back issues, so I can't move heavy things. And in that first picture of the first storage, you can see a big wooden heavy table there. And then
I don't have any pictures, and they haven't been admitted into evidence.
Oh, well,
so if he's doing month by month and you think all of that could go into 1 unit, then, you know, you can see if you can get that unit abated and put it all in 1 unit and get that money back.
Well, and Your Honor, the other thing is I had sent, oh, I'm sorry.
No, I may have made some comments of what I thought, but they weren't court orders and they weren't put in the court orders. I thought it would be around 2,000, but like I said, I don't know. And I really don't think a moving company is going to commit themselves to a price until they walk through and see what all's there. And then they're still going to charge you ultimately an hourly rate wherever you would end up, wherever that might be.
And they're right. Wouldn't include 6 months of storage unit. It would just include the moving charges. And my client did pay for 2 Men in a Truck to make 1 load to her house prior to you making this order. So they obviously couldn't have done it in 1 load because they didn't do it in 1 load. I think did they come twice even?
Yes.
Yeah, so he's paid for them twice actually to take loads to her house plus this order. So just wanted to remind the court of that.
Your Honor.
I want to get the equalization payment to you. And that's where we're at on this. This needs to be finalized and done.
And I understand that, Your Honor, but it was just the fact that it was 4,000, which in the court order you had said 2,000 max. And so I thought it would even out with the Walmart stock, and it would probably be around 2,000. But like I said, that wasn't put in the court order. That was not a finding by the court. There's no way for me to know for sure. And I did see those pictures, and frankly, it's almost a borderline hoarding situation. There's so much stuff there that unless a person went in and walked through there would be no way to know for sure how much moving and how much storage was going to be involved until you started doing that, frankly. So those were not findings by the court. And you had, Oh, I'm sorry.
I believe I'm finding today that they've complied with my order, except that I want to see receipts of any actual payments that are being declared. And my question to you is, do you want your money to go through the clerk of the district court, or do you want to pick it up at the attorney's office?
Could I just address the $4,000 bill?
No, no,
Oh,
no.
okay.
I told them that I want the expenses itemized. They did. This is what it ended up being. It
Because I'm
never
gonna
would have gotten to that if you had been able to make arrangements with friends or family or done something to reduce the amount of stuff or to get rid of this stuff. And this was a rather creative, I think, way in which to free him of your belongings that you just were not getting out of the house. And I ordered him to do it, and I ordered him how he could charge it, and he filed an itemization, and I'm going to accept it. And as long as he provides the receipts that I mentioned that you brought up, that perhaps there was some arrangement made where there's an assertion of payment where there was none. But other than that, I am approving it. I'm approving the offset to the equalization payment. You have an 83,000 something dollar check that you need to pick up. Because I sure wouldn't want it to be abandoned. So do you want to pick it up at the courthouse, or do you want to pick it up at the attorney's office?
Your Honor, could you tell me that
the attorney's office, you have to sign satisfaction of judgment.
Okay. On that, I'm sorry, on that itemization, the people that he used are my daughters and my grandchildren.
Well, I
To
mean,
move stuff.
that would be cheaper. I authorized him to do that at $10 an hour.
Okay, so is
Which
he
cheaper than 2 men in a truck, whoever he wanted to use to get paid for their time and their work in cleaning stuff up, packing it up, and moving it.
okay? And that, because a couple of my grandchildren are 10 years old. So is he writing checks to all of my daughters and my grandchildren then? Or is that
I don't know. You don't have a relationship with him where you can ask?
Well, he has complicated that, Your Honor, to be honest.
Well, that's sad. I'm just really sad about all of this.
Yeah.
But, you know, I didn't do an age limit. So, again, I think this is within reason, and I'm not going to rehash all of it.
Okay.
It's unfortunate, but I think it's due to the amount of stuff.
Well, and the other thing is, to be honest, he had moved items from the driveway. There were 3 filing cabinets that had sat outside in front of the garage for months. There's other tables that were sitting out there that were concrete tables. And I had asked him, I said, I don't want those because I was having someone come and pick them up from our house in Augusta, and they were going to trash them for me, and I was going to pay them. And what did he do? He moved all that stuff into the second storage. So now I have that's a lot of things that was moved to the second
I'm sorry.
storage.
You're going to have to send someone then to haul it off and destroy it. I don't think that he was going to destroy anything that was yours, even at your personal request, given the history of this whole thing.
Well, and that's why
I ask you a question. I need an answer to it, or you can go confer with an attorney and you can file an appeal and you can do whatever that you want to do. But I want this finalized, and you need to pick up the money that was awarded to you. So how do you want to retrieve it? At the attorney's office or at the courthouse?
What was the total amount of the check, Your Honor?
I don't know. I think I didn't really want to say it on the Zoom hearing, but it's 83.
I never
or
I never got any notice from Miss Scher on or the amount or anything. All I got was that phone call.
Okay, it is $80,895.
Yeah, okay. That's what
Okay.
I will pick it up from Miss Scher's office, and I would appreciate it if I could pick it up this week still, even tomorrow or Thursday at the latest.
Okay. Well, I'm going to ask that you do it by 5 p.m. or I'm going to allow her to file an order that I'll immediately sign and she can deliver it to the court on Monday.
My client needs to go back to the bank and exchange it again, so she can't come today, but if I can tell him to do that real fast after this hearing and she can come tomorrow or we're actually, we're closed on Friday. We've got an out of office thing, so she's gonna have to come tomorrow or Thursday.
Okay, well,
I will come,
that's when she wants to come, so I guess I'll say Thursday by 5.
I'll come and pick it up tomorrow.
Okay. All right. And you're free to consult with somebody to determine what, if any, filings that you want to make or do, or, but I need to get, this is the finality of it and need to get it resolved. And I do approve the expenses and the amount of the check, and that a satisfaction of judgment needs to be signed because it is the judgment of the court. All right, if there's nothing further, we are adjourned.
Judge, do you want me to draft order from today so that the record is clear?
Yes.
Okay. Your Honor, I'm sorry, Your Honor.
Yes.
How will I know if my daughters and grandchildren got paid by him?
You won't.
Oh.
You won't. You can ask him. You can ask him.
Okay.
I'm not going to have them come in and testify that they.
No. I just want to know that it's done so that they're not coming at me saying I need to pay them.
Well, they won't. You have no legal obligation to pay them anything. So you tell them the judge said that. I highly doubt if they haven't come to you by now that they're going to. All right, we are adjourned.
District Court for County of Washington, State of Michigan is now back in session. The Honorable Attorney General says.
You may be seated. That's, I thought. Court does call the case of Fixing Housing 401k Plan versus Erica Ward et al. Counsel, state your appearance.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Your name?
Good afternoon, Erica Ward and Aaron Ward, on behalf of ourselves.
All right. All right.
Your Honor, I believe my client representative, Mr. Hawk, is participating over Zoom.
Is that?
I think he is on his iPad.
iPad 4, I'll need you to unmute, state your name, and turn on your camera if you're participating in these proceedings.
He did actually post in the chat as Mr. Hawk previously. I can't even, I don't know that it's there though.
All right. Posted in chat is there. We'll need to.
Yeah. That was at 2 something.
I'll need visual confirmation. Otherwise, they have to get out of Zoom. All right, this date and time set for a couple of things, but mainly the motions in this case. All right.
Yeah, ready to go. The motions.
You ready to go?
Yeah.
All right, go ahead.
Your Honor, I'm not going to belabor the points that I've been making at multiple hearings. The lease expressly provides that tenants must pay monthly base rent of $5,500, quote, without any deduction or set off whatsoever. That is paragraph 3 of the lease. As the court correctly stated back in November, the lease language is not conditional. That transcript from that hearing is Exhibit E to our motion. Your Honor, tenant's sole defense is that the lease is actually residential, is frivolous. Tenants admit in filings with this court and the circuit court that they are operating a commercial horse boarding farm on the property. Tenants don't reside on the property, and it's a business collecting money from the boarders. I quote from their circuit court complaint, this is paragraph 2. Erica Ward leases the property to conduct her business. Willow Ward Equestrian LLC allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. This court, again, back in November, acknowledged the commercial nature of this lease dispute. Tenants argue that the lease does not use the word commercial. It does not use the word residential. It is a 7-year lease ending April 2028. Paragraphs 4 and paragraph 8B of the lease supports that it's a commercial lease. In the circuit court, tenants individually are bringing a business interruption/tortious interference claim against landlord, seeking alleged lost profit damages. So tenants are seeking alleged damages to their business on the property under the lease in the circuit court, while conversely arguing that the lease is residential in this court. Tenants signed a lease and guarantee. Landlord brought a breach of guarantee claim in circuit court. The separate guarantee agreement further evidences this is a commercial dispute.
Where is it dates? Go ahead.
Your Honor, Michigan case law provides that tenants may not withhold rent for repairs in commercial context. And I've cited these cases many times, the Rayum case and the Detroit Marine Terminals case. They provide in a commercial setting like this, the landlord's covenant to repair is independent of the tenant's duty to pay rent. Thus, any money claim for breach of the landlord's covenant cannot be set off from the rent that is due, and that's from the Detroit Marine Terminals case. Your Honor, I know that tenants have filed additional filings yesterday. I believe they also help my case.
Did we receive documents yesterday?
Yes, I simply filed an account.
On the front, got it. Okay, I see those. Okay, go ahead.
Your Honor, I just give you context. I received an email from Ms. Ward sending me pictures of the pages of these filings last night at 7 o'clock, and just received copies of these filings in this courtroom today. They reattach Ms. Tope's affidavit, which was the reason for the show cause hearing. I can dig into the substance of Ms. Tope's affidavit, but none of that changes that the lease says what the lease says. And they did not have the right to withhold rent. And actually, there are paragraphs in the affidavit that support my position. If you want me to go through those, I can.
No, I don't know that would be necessary, quite frankly. But go ahead.
Your Honor, in their only defense is that this is actually a residential lease. There are no grounds for that. Please grant our landlord's MSD. Thank you.
Your Honor, actually, that is not the case. The past 2 weeks, based on review, we fully understand that the lease has been deemed a commercial lease, and that under a commercial lease, you cannot withhold rent. However, we believe our motion for dismissal with prejudice should be heard, and that their entire basis for their summary disposition or the request for summary disposition is based off of a retaliatory lease, based off the fact, and I have emails.
Retaliatory lease.
Of retaliatory eviction. He sent me an eviction notice within 7 days of replacing the water heater, which, Your Honor, he continuously says that we made a unilateral decision to replace the water heater when I have documentation, which unfortunately I just thought of showing you this and I can't because I didn't submit it. But he knew about the water heater. He told us to have someone come out. We had the professional come out and we submitted our June payment of $2,800 after fixing this because the professionals told us this is a 30-year-old water heater. There's a gas leak, it's toxic and it's dangerous. So there is a statute under MCL 65720 that states they cannot evict me within 90 days of me going to them requesting things that are, as he stated, the lease says what the lease says. Granted, regardless of whether it's a commercial lease
Well,
or residential
but
lease.
you're quoting the retaliatory eviction statute.
Yes. Because their whole case, they're requesting summary disposition based off of a case that an illegal case that they're bringing against us. Because it was June 1st or 2nd that we notified them.
Ma'am, read that statute and tell me the language in that statute that you believe is applicable to this circumstance.
If the landlord started the eviction proceeding within 90 days after we, the tenants, tried to enforce our rights against the landlord who did not respond to fix a dangerous, toxic, fire hazard gas leak in the residence of the property in June, I informed the landlord of the hot water tank that it had not worked and that.
Slow down. So
Okay.
You're saying you informed him of it.
And he told us.
But he told you to repair it. Right? He gave you permission to repair it, you're saying.
He gave us permission to have a professional out.
Okay. And
that did
that,
nothing.
but what did nothing?
And then no more communication until the 13th when I got emails telling me that he was replacing me, the bar manager. I couldn't collect my board anymore and all kinds of other craziness. Best way I can describe it. On the 13th. And so that is when I got a lawyer and I filed suit in circuit court against him on July 9th for breach of lease for many.
So you think that the reason that they're here in this case is because why? Because you sought to enforce your rights?
Yes, it's a retaliatory eviction, absolutely.
But I think you need to look at the retaliatory eviction statute a little bit closer and look at the cases under it. I don't see this as a retaliatory eviction case at all.
Okay, so I'm sorry, but I haven't really heard, was that his motion for summary disposition that that's the same thing I've heard. Is that what he's?
I mean, he's basically saying the lease says you can't withhold.
Absolutely, and that's fine. And if you were to grant summary judgment, then we would absolutely pay back the back rent minus, this is why I submitted this account.
No, but minus what?
Well, the things that he's responsible for in 6A and B of the lease. I've been asking him for years, since 2022. At a minimum, there's enough information to do discovery and have it heard before a jury.
I think jury at this point on this case at least is waived, so I don't think that's going to happen.
A trial.
Well, you can have a trial maybe. But basically, ma'am, these are counterclaims for payment under other provisions in the lease.
Correct, 6A and B, where it states that he needs to do this and respond within 48 hours.
Okay, but the bottom line is you would still owe the money. But you're saying that there are offsets or money that he owes you.
Correct. And it might, like you said, the law's the law, and Your Honor, but there's also justice, and so I don't believe that I breached the lease because I'm willing to pay back the back rent. I mean, I've been paying into an escrow, which I understand that was a wrong process, so that put us in a bad spot. So moving forward, we've put it in escrow with the court, as you, Your Honor, told us to do. We've never not paid rent.
Okay. Anything else you want to tell me?
Well, again, I guess I'm just asking you to consider that if we have to pay the rent that went towards repairs, which basically is investing in his property, yes, I would ask that you would.
Well, but you don't, hang on a second. Let me ask you this, Ms. Ward. There would be a difference between you paying rent, right? I mean, sometimes the way that these things end up in litigation is if you had paid all of your rent, but then these repairs weren't done, what would you have done?
Well, now I understand what I should have done.
Is what?
Pardon me?
Is what?
Is file a lawsuit against him and had you direct how to spend the money. Correct.
Well, I could have done that if it got to that point, or I could direct repairs be made or whatever.
Right. I understand
Okay.
that.
So in essence, what you have here is a counterclaim for these things.
That's what I'm asking you to consider. Yes, Your Honor, but obviously that's in your hand. I know, I say the obvious.
But in terms of the crux of their motion, that they're entitled to their rent without set off, you would agree with that? If you
Based on the law and the research that I've gone out and done on my own since I dismissed my lawyer, or she withheld, whatever you call it, then yes. I personally still think it's great.
So then tell me, just tell me this. Tell me any reason you believe I should not grant their motion for summary disposition as to liability.
Can you say that in another way? Because I know summary disposition, what do you mean as to liability?
Meaning,
Whether or not
I make the legal determination that they're right, that they're entitled to their rent without any set-offs. Now, that may not resolve what are your counterclaims.
Because without any set-offs was not even in the lease. The without any set-offs was in a separate document, which was a guarantee, which I also think is, if not illegal, definitely shady, telling me, okay, I'm not a commercial person. I mean, I had a friend who's not even a landlord tenant lawyer review this for me before I signed it. Okay, that's my fault. But he had me sign a guarantee completely not even in the lease that says no set-offs. The no set-offs, as far as I read in the lease and what I was going to was section 6A and B. So I didn't know what else to do when this landlord is refusing to do anything, to repair anything. And I have all the documentation asking him about it for well over since 21, actually. So no setbacks is not even in the lease. I guess that would be what my contention would be.
So are you saying then that you have the right to set off?
I'm saying you have the jurisdiction to make a decision, but yes, I do think it's gray. I think the whole thing is very suspect. I mean, we did, obviously that we filed a breach of lease on July 9th. And then it was in October, he's evicting me. And I paid the full.
July 9th in circuit court.
I filed in circuit court.
Right.
A breach of lease for all of the stuff that he's done.
And you're saying that because of your filing, this is retaliatory?
Well, it's retaliatory based on the first time that I spent my rent money on having this fixed, which he told me to have professionals come out and look at. He
But,
said, let me
but
know what they
hold on a
say.
second, hold on a second. That isn't retaliatory.
Well, he told me to have the furnace look, or the water heater looked at. I
Correct.
got it fixed, and then 7 days
Well,
later.
but
he
hold
told
on,
me
he
I'm-
tells you to, did he tell you to have it fixed?
said, let me know what they say. And when a professional comes out and says it's.
Okay, hold on a second. So he tells you to have the furnace looked at and let me know what they say.
I was gonna.
So, hold on. So did you then let him know what they said?
I paid while they were out there because they said to do it immediately.
So that's a no.
But he had established a process over the years. It's a no, Your Honor, correct. You are right. It's a no. But over the years, he had me hire, he finally, after months of asking him, I got an electrician out. He refused to pay the electrician. And we even said in the email.
But, you have to slow down. You're jumping around.
No, my heart rate's at like 140.
So but you keep talking about this retaliatory nature of things. And what I don't see this as a retaliatory eviction.
I don't, okay, then I'm not a lawyer, but for whatever reason, I've always paid my rent. He has set a precedence of saying, yes, fix this, go ahead, keep it out of your rent. I have done it 3, 4, 5 different times over since 2021. I'm not a commercial entity, regardless of the stupidity.
Okay, but here's the thing. If for a particular portion, you're saying that there are previous times where that's occurred. And those previous times, right? There was, in essence, an agreement in writing to deviate.
That's true.
Right?
After months of
Okay,
saying, "Are we gonna
okay,
pay this
okay.
guy?" Mhm. Correct.
So that both parties at that point agree that we're gonna pay this, and then this is the amount of the rent we're gonna send you. Right?
Let me concur. Yeah, that's true. He did not ever, he never sent a text that said, go ahead and take it up. There's multiple times it's happened. On occasion, he said, fine. Other times, he just ignored us. He ignored me for months at a time.
Okay,
And then
he
so
ignores
we
you,
pay
but
it.
what do you mean by he ignores you?
Can Aaron comment or am I?
I don't care who,
Okay.
he's part of this case too.
My wife is following an established process. We had a verdict go out.
Okay.
And have someone come out and fix it. We did. The plaintiff refused to pay him. I sent him several messages. I called him saying, please pay the person who deserves to be paid, or I will take this out of your lease. I never heard from the plaintiff. We took it out of lease.
And hold on a second. And what did he do because you took it out?
Nothing.
Right.
It's happened 3 separate.
So now on this occasion, right? Did he tell you to fix those things?
No, Your Honor, but I.
So hold on.
No,
because you're gonna have you've got a very different circumstance.
I believe we were just following the process that is established where things got fixed. We took out lease. Gas leak. I understand what you're saying completely, Your Honor.
It was a gas leak. I thought it was an emergency repair.
And the process had been, it gets fixed, we take out lease to have it be.
Well, that's the process where he says, fix it, have it fixed. Then the person you're saying is not paid, it doesn't matter to me about that necessarily. But at some point, you then take it out of the payment you're sending him because you've done it. But at the crux of that is him saying repair it. What we're talking about now, that didn't happen. That first part. right?
Correct.
You were just saying, I have a problem. He doesn't respond, may not respond, doesn't do anything, or says, have somebody come out and look at it and let me know. You then decide to sort of jump ahead, you repair it and then take it out. And what I'm indicating to you is, I don't think you could do that. The party certainly can deviate. If it were an established practice that you would just make any repairs that you thought necessary and then send him the balance, and that's the way it went, that'd be one thing. But that's not what this is. The distinction is, he says, because he has an obligation to make some of those repairs, he then says, just get it fixed. And then ultimately you take that out. And I think rightfully so, then when he said fix it, he doesn't complain about what she did. But it's when you do it differently that there's going to be the complaint.
I
No,
can't argue with you there.
You can argue with me all you want.
But you wouldn't listen anyway, but I know, I get it. I
The
understand.
reality
You
is,
shouldn't.
we're in a tough situation where I guess
I
unfortunately, people
thought-
know the plans have not paid, so we have someone who knows the plan's not going to pay, we need to get it fixed, and we thought we were following the process. I understand this stuff. It's very,
I don't think it justifies an eviction, and he wants the 2,800.
Well, and it may not, because understand that although this is a termination, I'm not clear that termination is necessarily going to be the result.
Well, that would be great.
Well, I don't know. I haven't made a decision. I haven't heard anything. The issue on their motion for summary disposition, I think it's the liability for the rent, liability for the breach. Yeah, but I can just certainly decide on the remedy, which is why I was trying to get to the parties to have them understand that I really think the parties need to resolve this.
I felt we made a very fair settlement offer.
Well, I don't want to get into that, but I really do think it should be. So as to the issue of rent and liability for breach of the lease, but not as to damages and remedy, I'm going to grant the motion for summary disposition. As to the amount of damages and as to the remedy to be applied as being a summary proceeding, the court will make a later determination on that.
Say that one more time, maybe dumb it down a little. I got that you found in
They
favor.
win on, yes, I find in favor that the lease is interpreted in the fashion that plaintiff wishes it interpreted, and that is that you're not entitled to an offset for monthly rent. It still doesn't resolve the issue, and I don't know that we've gotten that far as to the issue of what repairs needed to be done, but they're not going to face liability for repairs that you made without their approval. That's probably going to be the practical effect for you. Got that? You're looking at me like you didn't understand what I just said, but I'm more than happy to explain what I'm doing. But you got it?
Yes.
Okay.
Your Honor, there's many things I'd like to respond to, but the breach of the lease is the grounds for the termination.
I understand that.
And that's why we're here to evict them. Your Honor, regarding any counterclaims, they have not pleaded any counterclaims. They filed an answer. They didn't file affirmative defenses. They didn't file counterclaims. That was when they had assistance of counsel. So any alleged counterclaims that they have should be deemed waived. And it's also the same thing why they rushed to court and filed in circuit. So I don't think there are any questions of fact as regarding their damages. They're trying to seek damages through motion practice.
I understand that. I understand what you're saying, but you're also requesting a money judgment along with just termination. You're not just seeking possession. Right?
Yeah, we're obviously asking for the money that's owed.
And what I'm saying is, I'm granting it as to liability that there's been a breach. The court possesses a great deal of latitude with what the effect of that breach will be, and as to the issue of liability. And I think the issue of liability, well, the issue of damages, which still would have to be decided by this court, may be up in the air. If there were repairs that needed to be made, it wouldn't be an offset on rent. They may have breached in that regard, but they may still be entitled to certain repairs which weren't done that they did from a monetary standpoint, not from a breach of the lease standpoint.
I understand that, Your Honor, but they would be off of counterclaims that they have not.
You can make that argument. I mean, but we still have to have damages here. So, because I haven't ordered damages. So there'll be a damages here on it.
Would the court entertain releasing any of the escrow because they have defaulted on the lease?
I think that if the parties, I would strongly consider it. If I felt there were good faith opportunity or good faith to try to resolve that portion of the matter. I mean, and I'll just put it this way. I think there was a timing of move out that, and I'll be blunt about it. A timing of move out to move livestock during the winter is cruel. It can be done, but there are a lot of effort. Livestock have to be moved to a different location. Then it's really best done in the spring. Or, well, really summer's not a great time to necessarily do that either. But I think the parties are certainly at a point that it really is an issue of move out. Paying and then moving out. And it's just an issue of timing, as far as I see it.
I mean, Your Honor, we were the first ones to offer a settlement offer, which was rejected.
And counsel, I'm not saying that you haven't. I'm just saying it's really an issue of timing. I think they're going to be better off being someplace else. I think your client's going to be better off having that property. It's just how many horses do you have there?
38.
38. It's how and what is a proper amount of time to move those 38. That's really the issue as far as I'm concerned. Yes.
If it's possibility that they could buy the business if they want.
That I'm not getting.
I don't even know where all the
I'm not
horses are
getting.
going to even go. Okay.
I'm not getting into that. I'm saying that if you had to move them, let's put it this way. The court said right now they breached this lease, their tenancy's terminated. I set the writ date. It's not going to be 10 days. And so I would suggest, given the court's ruling, that the parties be reasonable about a reasonable time to vacate the premises. Not too long, not too short. Otherwise, what's gonna happen is, if it gets down to that point, I am going to make that decision myself. I don't have a problem making that decision. And it's not gonna probably be good for either party. That's my only point. Okay? All right. Counsel, did you, I did not see it, and I don't know if you filed it, a bill?
I did not file it.
Pardon?
I did not file it because there was a moratorium on not filing, which I was following.
Yeah, understood.
I have that here. I think it should be increased because they filed something yesterday.
Yeah.
Which I had to review their pictures and then review the filings today in this courtroom. So I think it should be subject to an increase.
Well, here's what I'm gonna do. Hold that, because Ms. Tope is not here. And that was gonna be part of the,
I did find my emails if you want them.
your emails.
You wanted to know exactly whether I knew ahead of time or not,
Knew ahead of time of what?
that she filed something. You had asked for them at the last court. I couldn't find them on my phone. I don't know if you want them or not.
Well, did you know?
After the fact.
After.
Yeah, which is what I told you, but you had asked.
No,
Right, okay,
understand what, I figured that to be the case.
okay,
You told me that, I
Right.
took you at your word for it.
okay,
I believed you,
Good.
which is why I set the show cause,
okay.
because it was filed on your behalf without your knowledge.
Correct.
Okay, that was my point, which is why then I set the show cause in part for Miss Tope, because she's no longer the attorney of record. Now, in regard to that show cause, and why I'm gonna tell you to hold that, and you may be able to add to it at some point, counsel, but I issued an order to show cause to Ms. Tope on, what date was that? That was on January 20th. I set the hearing for today. Show cause was sent out. The 14 days was given, as best I could see from the file. It was certainly sent out. It was sent down to the clerk's office and mailed out. We then, where's the email? I just want to get the quote.
This is from her, my emails.
Right. Okay. We then get and I'm gonna say this a little bit backwards. We then get a email from Ms. Tope, and it's entitled 2 p.m. show cause today. And it's addressed to my judicial coordinator. And it says, hello, I have not gotten any notice at my address or email for the show cause D Tope. You show scheduled for today at 2 p.m. on Judge Simpson's docket. I do not know anything about this. I have not had any contact from the court about it and am unable to attend. That's what she signed, so that I can make the record clear. A notice to show cause was sent by the clerk's office. When I'm looking at the file, the process that the court follows, I sign off on the order to show cause. It's sent to the clerk's office and then sent out to the parties. That happened. Additionally, and it's odd that we received the response today, and I'm sure all of you probably would have seen this process in one form or another. But on January 27th, the first version of the docket, which is set for today, would have been sent out by email to the parties. You then get an updated version. I think it's the initials, and the updated version was sent out on January 30th to the parties, which would show it's scheduled. You're looking at the time. Then the day before, because things get moved around and whatever, we send out our final of it. For Ms. Tope to say that she had no notice of it or anything along those lines is just patently false, because I have the emails of those various dates, the 27th, the 30th, and the 2nd, where Ms. Tope is emailed directly at her email address showing this to be scheduled. So it is once again a delay on her part to not show up. I will go further to say that she consistently flaunts this court's orders by, when she's off of a case, filing documents. I don't mind the parties when they want to argue with the court, but the disrespectful manner in which she has argued before this court. Some people show their disrespect in different ways, but it's always noted with Ms. Tope, she is a member of the bar of this state. I do not take lightly issuing show causes against attorneys in the first place. Don't like to do it because usually, because they are officers of the court, I can command them to be before the court at whatever point I want them to be before the court. But her behavior to this court is, for a member of the bar, is atrocious. And what I think, at least as I've seen in 2 cases, predicaments which she has put individuals which she alleged to have or was representing is also, from my perspective anyway, atrocious and highly unethical in terms of some of the ways that she's been proceeding. So it is with great dismay, but when an attorney or someone tells me I'm not appearing, I know they've had notice of it and they refuse to come before the court. The court is only left with one other option, which is its ultimate way in which to compel someone to appear. And so I'm going to issue a bench warrant for Ms. Tope's arrest. Her bond in this case, your approximate bill, counsel, what's the approximate amount that you have at this point?
Your Honor, that I have at this point is $6,975.
Good enough. So I will issue a bench warrant. Bond will be set in the amount of $10,000 cash and or surety. That warrant will issue immediately. So that you know, what will happen is, and I have a feeling we will catch up with Ms. Tope very quickly. Once that hearing is then set, she is not in custody and hasn't posted bond, we will let counsel, we will let the parties know. At that point, I would like to see the billing.
Okay.
All right.
Yes, sir.
You follow what I'm indicating on that?
Yeah.
Okay.
Pilot before.
Pardon?
At that.
You
time,
can
bring it at that hearing.
bring it at that hearing with the amount.
Okay.
And then I will go from there.
Okay.
Anything from you guys?
I just need to know where I'm supposed to be next.
We need to set another date, but counsel, if you'll prepare an order consistent with the court's ruling today, I will set a hearing on damages as well as what will be the court's enforcement of its, the motion for summary disposition.
How far would you like to go?
So we have the 17th of February or March 3rd.
You don't want to be here the 17th. I'm gonna just tell you, it's gonna be ugly day.
Yeah.
So I wouldn't do that to you guys.
I'm sorry, what were the dates again?
And my next date is what, March 2nd, March 3rd. 30 days from today.
March 3rd, we're flying back from my.
Pardon?
On March 3rd, we have me flying back and see my mom in Texas.
Possible to get a different date?
Well, it's always possible, but
March.
it would be March 10th. That's a ways out, but I think that's what I'll go with. If those are my options, so I'll
Would you
adjourn.
be able to go Zoom? Well, no, we can't.
Maybe we can't. Mom's 80.
So basically, so that you know, that's going to be, having granted the motion, that's going to be the court's determination of the eviction date and the money that's owed.
March 10th.
On March 10th. (2026) at 9 a.m. Anything else? No? Hearing none. Thank you, folks.
And now we know how that taupe crumbles. That's one heck of a trope for one heck of a taupe. I don't know how many of these things I can pull off. It's kind of silly. It really is. But ladies and gentlemen, that's all I got. That's all I got for now. That's not all that happened today. It's not even let me open this up. It's not even all I could put together theoretically, but it's all I could fit in this 2-hour chunk of time. And I thought it was all pretty interesting, from the Middleton to the Satterfield, most definitely with the Simpson. And I'm going to tell you right now, there was a nice little hearing in McNally and another at least 1 hour long hearing in Judge Simpson that I took a hard look at. We'll be passing on it for now, but stay tuned. You know, we still got that weekend review. We got one thing on docket for the weekend review, maybe two now, maybe two, and it may be an extra long one. Who knows? Ladies and gentlemen, stay safe out there. Be good to each other, and thank you so much for coming out. And while I have you here, I do want to say a special thank you to Rhonda, you crazy mod. Thank you so very much for your contributions. And Heidi Marie, am I saying that right? Heidi Emery? I didn't even give you a little heart on yours. Here, I'm giving you a heart now, because I really appreciate your contributions. Ladies and gentlemen, come hang out with me again tomorrow night. Same Wolf time, same Wolf channel. That's around 8 p.m. Central Time, 9 p.m. Eastern. Always. Oh! Yeah, Papa coming in with the late. Thank you so much. It's all appreciated. Come on by tomorrow. Heidi Emery. Hey, I got it right. Yay. Come on by tomorrow and hang out with me. I plan on having a great, huge, fabulous, amazing, interesting show. I mean, it's all educational, but who says you can't have fun while being educated at the same time, right? Well, that's what I say. And what I say goes, at least for now, until I go. And that's what I'm doing right this second. Ladies and gentlemen, I am your Lone Wolf Usul. I'm your curator for these here videos and your host for this here channel at the Court Gallery. And I am out. Nope, nope. Not Tope. Nope, nope. Not Tope. There she go. That's Tope. There she go. Tope. You got a bench warrant. Tope, turn yourself in. Bye.